Well, my talented and respected brothers and sisters, this is Advocate P. Nagarik talking to you from Ahmedabad, Gujarat State, India, that is Bharat. Today I have selected a very nice topic, so I'm excited to talk to you on default bail. In Gujarati it is said Moodbhoot Jamin. The Code of Criminal Procedure, Code 1973, Section 167, subsection 2. And from effect 1st July, new law comes into existence. Bharatiya Nagarik Suraksha Sahita 2023, Section 187, subsection 3. Subject matter is same. Procedure when investigation cannot be completed within 24 hours. Now, Bharatiya Nagarik Suraksha Samhita 2023 Section 187 reads subsection 3. The magistrate may authorize the detention of the accused person beyond the period of 15 days if he is satisfied that adequate ground exists for doing so. But no magistrate shall authorize the detention of the accused person in custody under this subsection for a total period of exceeding 90 days. This is written also in 167 of CRPC Section 2, Clause A, Subclause 1. 90 days where the investigation relates to an offence punishable with death, imprisonment for life, imprisonment for a term of 10 years or more. Now, Section 167, subsection 2, Clause A, Subclause 2 talks the same thing like 187, subsection 3 of Bharatiya Nagarik Suraksha Samhita 2023. 60 days where the investigation relates to any other offence, and on the expiry of the said period of 90 days or 60 days, as the case may be, the accused person shall be released on bail if it is prepared to and does furnish bail, and every person released on bail under this section shall be deemed to be so released on regular bail. Subsection 4. No magistrate shall authorize detention of the accused in custody of the police under this section unless the accused is produced before him in person for the first time and subsequently every time till the accused remains in the custody of the police, but the magistrate may extend further detention in judicial custody on production of the accused either in person or through the audio-video electronic means. There is one provision for ladies, provided that in case of woman under 18 years of age, the detention shall be authorized to be in the custody of a remand home or recognized social institution. The basic parameter is that the charge sheet has been filed after the completion of the investigation or not. This is to be decided. Section 167(2), equivalent new law, BNSS, Section 187, subsection 3, has to be interpreted keeping in mind the threefold objectives expressed by the legislature. What are the objectives of the legislature? Number 1, ensuring a fair trial. Second, expeditious investigation and trial. And the last but not least, setting down a rationalized procedure that protects the interests of indigenous section of society. What is the role of court? The court is a guardian of the rights bestowed upon the accused persons strict compliance of the procedure is necessary to protect the fundamental rights of an individual. Merely filing of the charge sheet, whether incomplete or piecemeal, cannot defeat the basic purpose of Section 167 subsection 2, that is, BNSS 187 subsection 3. Here the point is, if police decides that this one should not get default bail, even though investigation is not completed, so he sends charge sheet, piecemeal charge sheet. Court will not allow it. Presumption of innocence is also inbuilt in this provision. It is pertinent to mention that the right of default bail under Section 167 subsection 2 or under new section, under new law, is not merely a statutory right, but a fundamental right that flows from Article 21 of the Constitution of India. Now, from the above mentioned legal provisions, the following questions have emerged. What are those questions? I'll be asking a question, I'll put a question, I'll also give the answer for that. Can a charge sheet or a prosecution complaint be filed in piecemeal without first completing the investigation of the case? No, sir. Answer is, without completing the investigation of a case, a charge sheet or prosecution complaint cannot be filed by an investigation agency only to deprive an arrested accused of his right to default bail under Section 167, subsection 2 of CRPC. Now, next question. Whether the filing of such charge sheet without completing the investigation will extinguish the right of an accused for grant of default bail? Answer. Such a charge sheet if filed by an investigating authority without first completing the investigation would not extinguish the right of default bail under Section 167 subsection 2. Accused can get default bail. Question 3. Whether remand of an accused can be continued by the trial court during the pendency of investigation beyond the stipulated time as prescribed by the CRPC or new law? Answer. The trial court in such cases cannot continue to remand an arrested person beyond the maximum stipulated period without offering the arrested person default bail. London magistrate has to offer bail, default bail to the accused. If he doesn't furnish bail, then he can remain in custody. Then London magistrate cannot do anything. But if he prepares himself for the bail, if he gives the bail before the court, then honorable court has no other option but to release him on default bail. Now, all these arguments are based on the law as well as on the two citations. Number 1, 2023, in bracket 3, Crimes 89, Supreme Court of India. Ritu Chabaria versus Union of India. Now, next one is 2023, Criminal Law Journal 3160, Delhi High Court, Central Bureau of Investigation versus Kapil Wadhwan and another, decided on 30th May 2023. Hope you have got some useful information in this video. Hope you enjoyed this video. Now, if you are a regular viewer, then you have not to subscribe it if you have subscribed it once. Even though you are our regular viewers and if you have not subscribed it, please do it now. Subscribe it, enjoy it, share it and like it. I'll see you in the next video. Thank you for joining us. This is our continuous journey for the self-development, and I thank once again from my bottom of the heart. Thank you, thank you, thank you.